Imagine this. You open your eyes for the very first time in a hospital room somewhere in Los Angeles or Chicago or Houston. Your parents look down at you with hope and relief. All the while, perhaps, they're wondering, will this new life be truly American? Will their child be recognized as a citizen, as has been the promise for generations? Or will a sudden, dramatic shift in national policy turn that dream to dust? This isn't just a thought experiment. Right now, the United States stands at the edge of a legal and political earthquake. For over 1.5 centuries, birthright citizenship has been more than a policy. White has been a defining statement of American identity. Written into the 14th Amendment in the late 1860s, less than 5 years after the Civil War, it was intended as a beacon of equality and inclusion. All persons born or naturalized in the United States, and subject to the jurisdiction thereof, are citizens of the United States, it reads. This clause, simple but profound, has given hope to millions upon millions of families seeking freedom, opportunity, and stability. But now, this promise, long seen as ironclad, is under siege. In the early days of his new term, on January the 20th, 2025, President Donald Trump signed a sweeping executive order. Its intent? To end birthright citizenship for children born on American soil to undocumented immigrants and even to foreign visitors, such as tourists and students. The rationale, according to the administration, is to protect American borders and discourage illegal immigration. Supporters of the order argue it will safeguard resources, solidify national security, and ensure the integrity of the American social contract. Yet, for every cheer that greeted the policy in some corners, there was a wave of alarm and outrage in others. Critics, including legal scholars, civil rights groups, and much of the immigrant community, see the executive order as a direct and dangerous assault on the Constitution itself. The American Civil Liberties Union, often at the forefront of legal battles over civil rights, declared the executive action an existential threat to the American dream and a betrayal of generations of legal precedent. The reaction was immediate and explosive. Across the country, federal judges issued nationwide injunctions, emergency court orders that blocked the policy from taking effect while the courts weigh its legality. These injunctions, sometimes controversial but deeply significant, have become a tool for the judiciary to rein in executive power, especially when fundamental rights are at stake. Within days, the White House fired back, arguing that lower court judges should not have the power to halt presidential orders affecting the entire nation. They claimed it was an abuse of judicial authority and an obstacle to the policies President Trump was elected to enact. The controversy quickly reached a fever pitch as the case made its way to the highest court in the land. On June the 27th, 2025, the Supreme Court delivered a decision that would reshape the legal landscape. In a 6-3 ruling, the conservative majority, led by Justice Amy Coney Barrett, dramatically curtailed the ability of lower federal courts to issue broad, nationwide injunctions against executive actions. Barrett wrote, "Federal courts are not meant to serve as perpetual overseers of the executive branch. Their power must be exercised with restraint and according to constitutional boundaries." Justice Sonia Sotomayor, one of the court's leading voices on civil liberties, issued a passionate dissent. She called the decision a travesty for the rule of law and warned it would expose the most vulnerable among us to the unchecked power of the executive. The Supreme Court, however, notably sidestepped the core question. Can the president, by executive order, actually revoke birthright citizenship, a right that has been guaranteed for over 150 years? The justices left that issue to be addressed by lower courts, even as the administration's new standard on injunctions allowed Trump's order to edge closer to enforcement. But the legal story was far from over. In the state of New Hampshire, U.S. District Judge Joseph LaPlante, responding to the new landscape set by the Supreme Court, took a bold step. He certified a class action lawsuit this time, not just on behalf of a handful of plaintiffs, but on behalf of every single baby born on American soil since February the 20th, 2025, to parents without legal status or who were visiting temporarily. The American Civil Liberties Union, representing the plaintiffs, argued that the executive order would strip away citizenship from potentially hundreds of thousands of newborns, violating both the letter and spirit of the 14th Amendment. Judge LaPlante's decision to certify the class action lawsuit was a strategic move. While the Supreme Court had limited the power of nationwide injunctions, a class action suit allowed for a collective challenge, representing all those potentially harmed by the policy. In effect, it paused implementation of the executive order once more, giving the federal government 7 days to appeal. The White House, unsurprisingly, was furious. Harrison Fields, The administration's spokesman condemned the ruling as an obvious and unlawful attempt to circumvent the Supreme Court's clear order against universal relief. This judge's decision disregards the rule of law by abusing class action certification procedures. The Trump administration will be fighting vigorously against the attempts of these rogue district court judges to impede the policies President Trump was elected to implement. Meanwhile, organizations like the ACLU saw this as a crucial victory in a long and grueling fight. Cody Woofsey, an attorney for the ACLU, called Judge LaPlante's move an inspiring act of judicial courage, defending the very heart of the Constitution. The stakes, at this point, could hardly be higher. On one side, the White House and its supporters argue that unchecked immigration threatens the nation's economic stability, security, and social fabric. They point to concerns about resource allocation, welfare costs, and the integrity of the nation's borders. Some cite data suggesting that as many as 350,000 babies are born each year in the United States to parents without legal immigration status, a figure that has fueled political debate for years. On the other side, civil rights advocates, constitutional scholars, and a broad swath of the legal community warn that the executive order threatens to unravel one of the United States' most fundamental democratic promises. If birthright citizenship can be stripped by executive fiat, they argue, then no constitutional right is truly safe. Samuel Bray of Notre Dame Law School observes, this ruling has fundamentally reset the relationship between the federal courts and the executive branch. The balance of power that has defined our system for over 2 centuries is shifting before our eyes. For families across the country, the uncertainty is deeply personal. Imagine being a parent who crossed borders in search of safety or opportunity, only to face the prospect that your child might be stateless, lacking any recognized citizenship anywhere in the world. Or consider families with one parent on a student visa, or a business traveler whose child is born prematurely while visiting the United States. The executive order, critics say, would cast a long shadow over the lives and futures of these children, who could find themselves in legal limbo, denied basic rights like access to public education, healthcare, and even the ability to apply for a passport. The consequences could be felt far beyond the affected families. The United States has long prided itself on being a nation of immigrants, with a social fabric woven from countless stories of newcomers building new lives. The 14th Amendment's promise of birthright citizenship was, in part, a response to the horrors of slavery and the need to guarantee full personhood to all born on American soil, regardless of race or ancestry. Overturning or limiting this right could send shockwaves through the nation's self-image, as well as its legal and economic systems. But how did we get here? To truly understand the gravity of this moment, let's take a brief detour through history. The principle of just solely citizenship by birth on a country's soil originated in English common law. When the 14th Amendment was ratified in 1868, its authors sought to undo the infamous Dred Scott decision of 1857, which denied citizenship to African Americans. The new amendment was meant to ensure that the accident of birth, not the accident of ancestry, would determine who belonged in the United States. Since then, the courts have reaffirmed this principle time and again. In the landmark Wong Kim Ark case of 1898, the Supreme Court ruled that even the children of non-citizens born in the United States were entitled to citizenship. The decision became a touchstone for generations of immigrants, providing a foundation of legal certainty that allowed millions of families to put down roots, build businesses, and contribute to the American dream. Fast forward to the present, and the debate over birthright citizenship has become a lightning rod in the broader clash over immigration. Some lawmakers have attempted to introduce bills in Congress that would limit the scope of the 14th Amendment, arguing that it encourages so-called birth tourism or incentivizes unauthorized immigration. Yet, none of these efforts have passed into law, and the overwhelming majority of legal scholars maintain that only a constitutional amendment, a process requiring 2/3 approval in both houses of Congress and ratification by 3/4 of the states, could fundamentally alter birthright citizenship. To put that in perspective, in more than 2 centuries, the United States Constitution has been amended only 27 times. The last amendment, which dealt with congressional pay, was ratified in 1992, over 30 years ago. Changing the Constitution is an arduous process, reflecting the founders' intent that fundamental rights should not be easily swept aside by shifting political winds. So what happens next? The Trump administration, undeterred by lower court setbacks, is expected to appeal Judge LaPlante's class action ruling. Should the appeal succeed, the Supreme Court could be forced to confront the core question it previously avoided. Does the Constitution allow the president to unilaterally end birthright citizenship for children born on American soil to undocumented or temporary residents? Some experts, like Justice Brett Kavanaugh, have hinted that the Supreme Court will ultimately serve as the final arbiter of this monumental legal challenge. The Supreme Court remains the ultimate judge of federal statutes and executive actions of this magnitude, Kavanaugh wrote in a concurring opinion. The court's eventual ruling could set a precedent with consequences echoing for generations, either reaffirming the century-and-a-half-old promise of the 14th Amendment or opening the door to a fundamentally new understanding of American citizenship. Other scenarios are possible too. Congress could take up the issue, either by attempting to pass new legislation clarifying or constraining birthright citizenship, or even by proposing a constitutional amendment. Such a move would likely ignite a political firestorm, as lawmakers and activists on both sides mobilize for a once-in-a-generation battle over the nation's identity. The process would be long, contentious, and highly visible, with families, advocacy groups, and the media all weighing in. Meanwhile, the lower federal courts may continue to issue conflicting rulings, creating a patchwork of citizenship rights that vary from state to state or circuit to circuit. This legal fragmentation would leave families in a state of profound uncertainty, with the status of their children potentially determined by geography rather than by a uniform national standard. Justice Sotomayor, in her dissent, warned of precisely this danger. The government risks bypassing the Constitution and eroding the rule of law itself. The effects of these legal battles are not confined to the courts. Across the country, advocacy groups have launched digital campaigns, organizing rallies, petitions, and social media drives to raise awareness and pressure lawmakers. New technologies, from artificial intelligence-powered legal research tools to encrypted messaging apps, have become essential in the fight to defend or challenge birthright citizenship. In a world where information travels at the speed of light, the public's understanding of complex legal issues has never been more critical. For the millions of people watching, whether they are U.S. citizens, immigrants, or global observers interested in economics and technology, the outcome of this struggle will set powerful precedents. If the executive branch can strip away fundamental rights with the stroke of a pen, what other rights might be at risk in the future? Conversely, if the courts are hamstrung in their ability to check presidential power, the delicate balance at the heart of American democracy could tilt in unexpected and potentially dangerous directions. From an economic perspective, the question of birthright citizenship reverberates through nearly every sector of society. Undocumented immigrants contribute billions of dollars annually in taxes, labor, and consumer spending. Their children, when granted citizenship, often go on to pursue higher education, join the workforce, and serve in the military, becoming integral parts of the American economy. Restricting citizenship could have far-reaching consequences, not just for individual families, but for the nation's long-term competitiveness and social cohesion. History offers sobering lessons. In the early 20th century, laws like the Chinese Exclusion Act and the Immigration Act of 1924 imposed harsh restrictions on newcomers, often with devastating effects on families and communities. Decades later, these policies are widely recognized as discriminatory and contrary to the nation's founding values. Today's battle over birthright citizenship echoes those earlier debates, raising critical questions about who belongs, who decides, and what kind of country the United States aspires to be. So, as the deadline for appeal approaches and the legal drama unfolds, one question looms larger than any other. Could this be the moment America overturns a century and a half of birthright citizenship? Will the courts reaffirm the promise of the 14th Amendment? Or will Congress and the executive branch reshape the very notion of American identity? While the Supreme Court has not yet weighed in on the core constitutional question, the stakes have never been higher. Every child born to parents without permanent status now faces an uncertain future, caught between shifting legal standards and the unpredictable winds of politics. For lawmakers, judges, and activists alike, the coming months will be a test of principle, pragmatism, and the nation's collective character. The secret reality is that this battle is about far more than immigration policy. It is about the future of constitutional rights, the power and limits of the presidency, and the resilience of the American legal tradition. Whether you believe birthright citizenship should be protected at all costs, or think the time has come for change, these events reveal just how fragile and fiercely contested the idea of citizenship truly is. What do you think? Should the promise of birthright citizenship endure, or has the time come to reconsider the nation's oldest guarantees? Let us know your thoughts in the comments below. And if you found this deep dive helpful and thought-provoking, please subscribe for more stories at the intersection of law, technology, and global economics. In a